Good morning once again. We have all our speakers here present. Thank you all so much for being a part of today's webinar. I will hand over to to Chidima to do the introductions so that the webinar can begin.
Hello everyone, welcome to another exciting edition of the ESQ Practical Lawyers Academy free webinar series. We are glad you could join us today. My name is Susan Agu and I'm a research and development employee of trainees at ESQ Training Limited. At ESQ Training Limited, our mission is to expand the frontiers of continuous professional learning. We are committed to development of a robust and easily accessible, comprehensive source of practical information and continuous legal education and professional development for lawyers and other professionals. This we achieve by providing the highest quality accredited professional education in a variety of formats for lawyers, accountants, tax experts, oil and gas experts, and other professionals. We offer courses and trainings across various parts of law, which we have categorized into academies like litigation and other resolution academy, intellectual property law academy, Energy, Oil and Gas Academy, Corporate Law Academy, Tax Academy, Arts, Sports, Media and Entertainment Law Academy, Construction and Capital Project Academy, Capital Market Academy, amongst others. We have tagged this webinar series the Launch Hour webinar series as they are slated to hold at 1 p.m. during lunch break. They will hold 3 times every week, Monday, Wednesdays, and Fridays. However, in order to accommodate our Muslim participants, the Friday webinars will hold at 11 a.m. and every session will provide the resources in easily accessible formats on the go for everyone who's interested. Currently, registration is ongoing for our training on power. It's a 12-week virtual distance learning course titled The Dynamic of Power Contract Regulations, Contract Negotiation, Documentation, and Project Financing. And it commences on the 16th of February 2021, and we don't want you to miss it. To get more information about all this, please send a mail to esq-law.com. So the topic of today's webinar is termination of employment, the employer's right to hire and fire at will vis-a-vis an international best practice. The year 2020 has been a year filled with many revelations and happenings. A lot of sectors were affected by the COVID-19 and termination of employment was not left out. Today we'll be taking a look at the recent trends and developments in employment law and a projection of how the employment law will be as regards an employer's right to hire and fire at will. Our seasoned facilitators will also advise professionals on new industry trends and skills to flow into the new normal. And we'll be looking at identifying the trends in employment law post-COVID, discuss some recent cases employment law, outline the recent legal, business, and institutional developments in employment law, understanding the dynamics of employment law and the rights of employers and employees of multinational companies, identifying the future of employment law and the labor market in general in the new normal. We are privileged this morning to connect with our panel of experts. And if you have any questions while the webinar is going on, please type in the Q&A or raise your hand. It is with great delight to introduce you the chair and moderator of today's webinar. He is Mr. Jamil and he's a professional assistant, and he is a trusted professional association of labor lawyers. He is a member of the Nigerian Bar Association Employment and Industrial Relations Committee. He is an insightful and prolific writer, and he has written articles on various areas of employment and commercial law. He is the author of the Employment Law Handbook, which is a seasoned and well-researched book that gives insights on the employment and labor law in Nigeria with an in-depth understanding and analysis of the critical issues relating to labor matters with different collections of legal opinions on employment law, a brief synopsis on employment law and regulations and employment law precedents and templates. He is currently a legal counsel within the global litigation team of the Shell Petroleum Development Company, SPDC. Before joining SPDC, he was the Dispute Resolution Counsel in Adeketun, Caxton, Martins, Abo, and Shegun, a top-tier commercial law firm, where he was part of the employment litigation team. He has advised extensively on employee wrongful termination claims, redundancies, executive compensation for workplace injuries, and has also represented high net worth clients in various courts in Nigeria. And with great pleasure, Mr. Jamil, we want you to share this topic and take the floor. Thank you.
So good morning again. Good morning, everyone. Good morning. Thank you for that kind of introduction. I'm happy to be here, and I'm sure the speakers too are happy to attend this launch webinar without lunch. I was saying, I'm not sure if Esquire has virtual lunches to share, or if they'll be dispatching to our different offices. But I would welcome everyone to this webinar. By my screen, I have 38 people welcome. That's a sizable number to start off with. And I think we're all here for one primary reason, to share ideas on this, what I consider to be the most basic of aspects of employment law. I mean, even if you're not a specialist employment lawyer, the average lawyer knows at least the issue of termination or dismissal when it comes to employment law. But recently, I think we've had a whole lot of uncertainty in this aspect of the law. And that's why we brought this high-powered panel of experts to shed some light and share some perspectives on this issue. Can you confirm if you can hear me?
Clearly.
Okay, great. Okay, so I have some of my colleagues here. Let me see. Let's introduce the ladies first. Ladies first in everything, but the hardest things, right? So on my panel for this morning, I would want to introduce my good friend, Ifedayo Iroche. You would please excuse me for being biased. Yes, she's a woman. They should have priority, but she's also a colleague and a fellow member of the Employment and Labor Law Association of Nigeria. She's currently legal counsel with Coca-Cola Hellenic Bottling Company. I hope I got that right, but yeah, Coca-Cola. And before then, I knew Ifedayo as a very strong member of the commercial law firm of Petstone and Grace in Lagos. Ifedayo is a very strong employment law person. Last year or so, was it last year or 2 years, we were together at the employment law seminar organized by the MBA section on employment and industrial relations. And pretty much very strong views she shared then, restrictive covenants, I could say. I mean, I was listening to it, I was just opening my mind like, come on. So that's how passionate she is about a very passionate leading area of the law. So welcome, Ifedayo. I hope you're doing great.
Hi, Jamil. Thank you. Yes, I am. Thank you for having me. Just to quickly highlight, I'm with Coca-Cola Nigeria, CCNL, not Hellenic. Okay. And yes, it was 2 years ago when I was at Chi. That was the last time you and I saw. Yes.
Okay. Thank you. Thank you for that. Welcome. On the panel is also Mr. Solomon Ezike, who is a Nigerian trained lawyer with over a decade's post-qualification experience in dispute resolution, commercial and energy law practice. Is currently an LLM candidate in the American University Washington College of Law in the US. Before then, he was a senior associate at the law firm of G. Elias and Co., which is one of our top commercial law firms in the country. Of course, Solomon has extensive experience in advising on labor law matters and in general, foreign investments in Nigeria. Award-winning scholar, so many articles on doing business in Nigeria that you have published in journals scattered all over the world. So it's not your local lawyer at all. But Solomon, you're welcome. Your experience is quite evident in your write-ups, and we'll be happy to share some of your immense knowledge this morning. Also, we have Busayo Adedeji here. Busayo is another astute legal practitioner with so much experience in labor and employment law. He's currently a legal consultant with New Edge Legal Practitioners in Lagos, and also another person who will gain so much insights in advising various businesses in navigating the area of employment and labor law. And then last, but certainly not the least, I had to balance it, start with a lady, end with a lady, is Motunrayo, another fantastic lawyer, senior associate in one of the leading law firms right here in Lagos, Busayo is a senior associate in the firm and is a frontline member of the firm that advises on labor and employment. Motunrayo, I beg your pardon, graduated from the University of Lagos, a senior associate in BA law firm. And I was saying that she got called to the Nigerian bar in 2018, and she's been with the firm advising matters. So with that short introduction, I am sure, they say the taste of the program now, the taste is included, right? So by the time you hear this high-powered panel speak, I'm sure you will do a better introduction of themselves. And so welcome. Welcome, guys. We're here this morning to talk about a topic that really take the whole day or the whole week. Indeed, it's a conversation, it's a debate that has been raging for quite a while, depending on who you ask. The preview or the synopsis of this seminar, of this webinar, tied it to the case of Bello and EcoBank, which is last year's decision, if I'm not mistaken. But before then, I personally, trace the genesis of this issue of termination to the very old Supreme Court cases like Shitabi, Federal Public Service Commission, Aloysius, and the Diamond Bank about 5 years ago. And then we have Bello and EcoBank. And it's thrown the whole industry, the business community into a frenzy about what exactly is the law saying on termination. Can we terminate with cause, or do we have the liberty to dismiss or terminate without giving any reason? Yes, all of us are used to the mantra, an employer can fire for good reason, for no reason, for bad reason, for no reason. It's almost like a nursery rhyme every lawyer has memorized. But is that really the case now? Maybe not, going by what is coming out of the National Industrial Court in recent times. I think we lost Solomon, so if the organizers could help see to that. Right. So that is the question we need to throw light on this morning. And okay.
Can you come again, please?
Motunrayo. Okay, so I was trying to set the scene for your paper. You're to share with us the recent court decisions on termination of employment. So what are the courts saying? What does the ILO Convention say? And why do we have this uncertainty all over the place? You have 15 minutes. If you please, you could set the ball rolling.
All right, thank you very much, Mr. So Yes, thank you very much. I would like to just briefly delve into contract of employment, because it goes without saying that an employer-employee relationship must be exempt, and there are different, and basically this can be divided. The office is held at pleasure, and where the master is under no obligation to be heard properly. Can you hear me, Mr. Jamie? Okay, yes. So as I was saying, that contract of employment can be divided into several categories, such as master and servant, or a situation where the office is held at pleasure. And basically, this is governed by a written contract, and the master or the employer is under no obligation to give reasons for terminating the appointment of the employee, as long as notice or payments in lieu of notice is given. And this is quite different from a contract of employment with statutory flavor, where the employer cannot just terminate the employee's employment without following the conditions laid down for termination. Basically, the common law position is that the employer or the employee may terminate a contract of employment if it comes from the employee. We would refer to it as a voluntary resignation. But if it's from the employer, it's basically the employer has the right to hire and fire, and this allows the employer to terminate the employment of the contract of employment, but it has to be in accordance with the written terms of between the parties, and anything that is short of this would basically amount to unlawful termination of employment, and it gives the employee a cause of action against the employer. There are several cases where this position has been stated, cases such as Akinfe and UBA PLC, which reiterates the right to hire and fire. At this point, I would say that this common law position is in total contrast with Article 4 of the International Labour Organization Termination of Employment Convention, which provides that the employment of a worker shall not be terminated unless there's a valid reason for such termination. Either it is connected with the capacity of the employer or with the employee rather, or with the conduct of the employee. So having established what termination means, I would move quickly to the concept of unlawful termination. I've recently had the conversation of termination with two people I know. The first one was someone who had not been to work in 2 weeks because she was ill. And all of a sudden, one day she refreshes her email and sees that her employment has been terminated effective immediately. Well, she wasn't given notice. She wasn't given salary in lieu of notice. And when she communicated this and copied our lawyers in the email, the employer rather agreed to pay salary in lieu of notice. Well, in the second scenario, the employer and the employee, they basically had some sort of toxic relationship. She had a new supervisor who was always picking on her, but she wasn't ever given a query, and no reports were made. So the environment continued in hostility until our employment was also terminated abruptly. Funny enough, in this case, the employer didn't sack her. She didn't get a letter of termination, but she was advised to resign. And she was told that, it wouldn't look good on her CV if it stays there that her employment was terminated after she'd worked in the company for so many years. So she basically thought about her options and decided to resign in line with her employer's advice. She received salary in lieu of notice and a severance package. So in this scenarios that I've mentioned, these employees were very unhappy and obviously wanted to know if they could sue their employers. And indeed, the question that arises is, what will actually entitle these employees to a viable course of action against their employers? And on the flip side, what do HR managers need to consider before letting an employee go? Well, it suffices to say that for both parties, the primary consideration should be the contract of employment and conformity with the provisions of the said contract in relation to issues such as notice, payment in lieu of notice, the reason for termination, particularly in instances of misconduct, the procedure for investigation, and ensuring ensuring that there was fair hearing. And I'll just briefly, touch on all of these issues. So the first is that notice must be given, and where no notice is given, there should be payment in law. It has been stated in a plethora of cases. I have a PowerPoint slide. I had assumed that it was going to be shared, but discussion. So the length of notice is usually 1 month, but the test of reason, which means that notice must be reasonable, and the standard of requirement of notice applies to both parties. So it means that either the employer or the employee who terminates the contract should give notice, and while the employer must offer payment in lieu, the employee who resigns without notice will also be willing to termination and dismissal. Well, dismissal is different from the punitive measure, which is taken as a result of misconduct on the part of the employee. So while termination can be done by either party, dismissal is usually done, or it can only be done by the employer. And basically, that if an employee is alleged to have behaved himself in an improper way, there should be an impartial investigation. The employee must have been afforded the right to fair hearing. And in what this means is that if an employee is found guilty of misconduct, the employment cannot be terminated, because that will in fact not amount to a termination, but if your employer, or rather, let me use myself as an example before you all start to unmute and say, God forbid, if my employer sacks me today, does he have to provide a reason for my termination? Your position that an employer is not bound to give reasons for termination has been challenged. I would refer to the Sterling decision, where the court decision was contrary to the old position that you cannot force a willing employee on an unwilling employer. And the summary of the fact of that case is that the claimant claimed that his employment was abruptly terminated by the defendant for no just reason, and in a bid to victimize him because he had challenged the activities of certain persons in the defendant's organization. And the defendant, on the other hand, argued that he owed the claimant no explanation and basically could terminate his employment for no reason at all. Well, in that case, the court held that the termination of employment of the claimant by the defendant was wrongful and unfair. The court relied on Convention number 158 and 166 of the International Labour Organization. And some of the findings of the court in that case basically were that if a termination occurs without notice, the letter of termination must be given at the same time with salary in lieu of notice, which wasn't done in this case. And relying on the ILO conventions and recommendations, the court stated that to terminate or dismiss an employee without giving justifiable reasons would be tantamount to unfair termination, especially where the employee was not found wanting in carrying out his duties. The court also relied on Section 254C of the Constitution, Section 7.1 of the NIC, and amongst others, saying that the court has the requisite jurisdictions of the International Labour Law Convention, even though some of them may not be domesticated in Nigeria. And the summary of all of this is that even though an employer has the right to terminate the employment of an employee, the employer must be satisfied that the employee has done something that is incompatible with the faithful discharge of his duty. And the burden is on the employer to justify the termination or the dismissal. A similar decision was also reached in the case of Afolayan Aderonke and Skybank. This was an earlier decision, and the fact of that case was that the claimant was suspended and subsequently arraigned before the disciplinary committee of the defendants for authorizing the payment of a check without citing the payee to come of the committee.
You have 4 minutes left.
Very well. So basically, the court relied on the ILO conventions and recommendations, as in the previous case, in adopting international labor practices and best standards, and held that it was unfair labor practice for the employer not to communicate the outcome of the investigation with the employee for almost 3 years, only for her to be served with a letter of termination and for no reason. And what I would say is that the judgment of the court in these recent decisions has reinforced the evolving dynamics in the workplace structure, and the court has shifted from the old common law position of hire and fire at will. And it is now a tenable argument that it is contrary to international labor law standard and best practice for an employer to terminate the employment of its employee without giving any reason or that is connected with the performance of the employee's work. And I would also say that Nigeria is the member of the and major participant of the ILO, and provide that there should be a valid reason for termination. From the Nigerian perspective, the typical argument would be that treaties are not enforceable as part of domestic law until they are ratified by an act of the National Assembly. Reference will be made to Section 12 of the Constitution and Supreme Court decision that it has to be ratified, otherwise it would have no force of law in Nigeria. But I would like to adopt what I consider the progressive approach, making reliance on Section 254C2 and which international best practices in labor and employment related issues. It is my position that the intent of the Constitution is for the NIC to apply international best practices in arriving at its decision and applying the ILO conventions which have been ratified, even when they're yet to be enacted by law by the National Assembly. And conclusively, I would say that it is a welcome development that the concept of unfair termination is that Nigeria's labor law covers a large extent of employees' rights are oblivious of these rights and employs with existing laws and treaties to ensure that arbitrariness is avoided and fairness is achieved. We have to strive to meet globally accepted standards of labor practices with respect to arbitrary termination of employment, and there's a need to ratify international conventions and reform existing laws as we recognize the importance of meeting the standards of the international human rights system. Thank you.
Beautiful speech, beautiful speech. I'm sure as you were delivering your speech in very eloquent terms, I am sure there are so many people in the audience stomping their foot and shaking their head vigorously at what you're saying. And that won't be, I mean, it won't be hard to fathom a guess as to why that is the case. Because even before this webinar, some people had who had seen my name on the flyer, I'd been sending quite some, I don't know what to call them, missiles, which I thought should be directed at the industrial courts, for some reason, directed at us, the practitioners. Now, a key point I want to pick out from what you said is the rationale, the justification for traveling abroad, so as it were, to impose a restriction on the right of employers to disengage their employees. Yes, we need to keep up with the times, we need to be progressive, we need to stop arbitrariness and all of that. Fine and good. All of that seems to be from the perspective of the employer. One of the strong pushback you get from especially business people when this topic comes up is, so what happens to the interest of the employer who's putting in so much capital and carrying so much risk business-wise to keep the undertaking going? And you're saying it shouldn't have the latitude to decide who he works with or not. How, in your view, do you think the interest of the employer is taken into account? Is there any sort of balancing act that you think the courts have even attempted to do in rendering these recent decisions?
Well, I think that these decisions are helpful for both the employer and the employee. And the court is not saying do not terminate an employee's employment. It just says give a reason. I think this is fair for the employer to, if there's an issue of misconduct, for example, conduct a proper investigation let the employee know what the outcome of the investigation is. And then, it's just to avoid arbitrariness or unilateralness. Basically, it's to get a balance. So if the employer has rights, then so does the employee. And it is important that this balance is reached. Provide a reason. If, for example, I am my employment is terminated and I'm wondering, okay, do I need to put this in my CV? If I'm asked where I'm going, why was my employment terminated? Is it as a result of something I did? All of these issues are things that the employee faces after an arbitrary termination of employment. So, well, I think these decisions are actually balanced, because it doesn't say do not terminate. It just says give a reason.
Okay, thank you, Moturaya, for your view, which I agree with to a large extent in terms of the reason, although whether the balancing act is well done by the court is still a very much debatable topic. But thank you very much for opening the floor for us. Busayo, you've advised so many clients, so high-profile clients, businesses, making so much money in the process, I assume, on this issue amongst many others. If I were an HR manager who has come to you for advice on how to disengage an employee, and I'm confused by the cacophony of noises over, yes, you should give reason, no, you shouldn't give reason, yes, your motive is relevant, no, your motive is not relevant, oh, this is the position of the NIC, no, the Supreme Court just said something different last week. As of today, what is it that you're advising your client? What are the things that HR personnel should be known? And that is one point I would like us to have at the back of our minds, or keep in mind while we're we have business people here who are not lawyers, so please tone down the defendant and respondent and all these things, and cut down on the legalese. Let's speak as plainly as possible so that we carry everyone along. But business people want it in bullet points. In summary, what are the things they should know if they were considering disengagement of an employee based on what the courts are saying and possibly our statutes? How would you go about giving that advice? So, Busayo, with that, can you share your thoughts with us?
Thank you very much, Jamil. Thank you for the pleasant introduction as well. By way of introduction, I would like to say that as well, the position of the labor law regime in Nigeria was that, as Moturaya also rightly mentioned, was that the employer could fire at will, could fire for no reason, any reason, bad reason at all. But under the current dispensation, the NIC is empowered by the 1999 Constitution, due to the last alteration to the Constitution, to apply international best practices in labor and employment. Prior to that, the NIC was also empowered by the NIC Act, the establishing act of the court itself, in section 7, subsection 6, to apply international best practices in labor. So I will try as much as possible to give this in key points, like you said, because of our business persons that are listening, like you rightly mentioned. So if I were to advise an HR practitioner or an employer who is considering terminating the employment of an employee, the first thing I would tell the HR practitioner is, one, you can no longer terminate the employment of an employee without giving any reason. When terminating the employment of an employee, you need to adduce a reason for that termination. This was the position of the court in the case of Shlom BJ versus Pengasan, and this is also in line with the provisions of the Termination of Employment Convention 1982 of the International Law Organization, ILO, where it was advised that an HR professional where it was advised that a employer seeking to terminate the employment of an employee must make sure the reason for termination is tied directly to the capacity of the employee to render his duties to the employer, or that the employee has displayed a conduct which the employer reasonably believes will be of adverse effect to his business. Two, another thing that an HR practitioner needs to bear in mind when looking to terminate the employment of an employee is that you can no longer terminate the employment of an employee with immediate effect. Because terminating the employment of an employee with immediate effect suggests some sort of wrongdoing on the part of the employee. So if you must terminate an employment of an employee with immediate effect, you must give reasons for such. Because in industries like the banking sector, if you terminate the employment of an employee with immediate effect, it taints the reputation of that employee in the industry. So if you are terminating with immediate effect, you need to adduce reasons, justifiable reasons, because as the last speaker rightly mentioned, the onus to prove that the termination is justifiable will always lie with the employer. Then leaving reasons now and speaking of a few other things that HR professionals and employers need to bear in mind as far as termination is concerned. HR professionals need to also bear in mind that regardless of the reason for the termination or regardless of the reason if it's a case of dismissal, all the earnings of an employee, all earnings that have accrued to a particular employee prior to termination must be paid as at the time of termination. It is no longer the practice, at least as far as the NIC is concerned, to terminate the employee or to dismiss an employee and expect that at the point of dismissal, all previous earnings that has accrued to that employee have gone. Another thing that needs to be borne in mind when terminating the employment of an employee is that this actually is at the level of drafting the employment contracts. HR professionals need to be sure, or whoever is drafting the contract needs to be sure that the termination provisions of the contract are clear and precise. They should leave room for no ambiguity at all. Because if there is any ambiguity, as simple as maybe failing to apply a comma or a colon where is necessary, the contracts, the provisions of that contract will be interpreted against the employer based on the contra preferential rule. Another thing HR professionals need to bear in mind when terminating the employment of an employee is that these days,
while we're waiting for Busaya to reconnect, I'll just move on to you because Busaya had barely 2-3 minutes left. I assume you've read the case of Bello and EcoBank, which I took time to read again while preparing for this session. And if you read that decision, and if you've read Honorable Justice Kanye, President of the National Industrial Court's decision in Aloysius versus Diamond Bank, you will see so much of a shift in the jurisprudence from the common law to what we can now call the new era of international best practice in industrial relations. And I was wondering, you are the, well, maybe apart from the moderator, you are the only business person on this panel in terms of having to sit on the side of the business. And from the business person's point of view, I guess it would be a rhetorical question to ask if you are satisfied with these decisions. But looking at the jurisprudence of the court in those cases, would you agree with the reasoning? Maybe not necessarily with the result, but with the reasoning. So I was saying that, you know, from the business person's point of view, you're reading EcoBank and Bello, you're reading cases like Aloysius Diamond Bank, and you're, you know, literally catching the jitters about where the court is tending. But from I wouldn't want to put you in a fix. I was going to say, from an objective point of view, going through the reasoning of the court, do you think it's something that can really be faulted in terms of why the law needs to move away from what the common law position is? And before you answer, perhaps to give some more insight into the case of Bello and EcoBank, for instance. In that case, an employee who has had no blemish on his record, who has, up to that time, not faced a disciplinary panel, not been accused of any wrongdoing, says that when he became head of a region of the bank, he noticed some malfeasance in terms of financial dealings within the bank, and he tendered emails in the course of the trial showing that he had raised issues with the way some people were, fleecing the bank, and that was when his troubles began. The bank did not contradict any of this during trial. And he basically made out the case that he was a whistleblower. He was, exposing rot within the bank, and maybe that ruffled some feathers. And the next thing he saw was a suspension and then later termination. And the court said, well, that can't be right. Should it be enough for an employer with all of these facts in the open to just say, well, I just don't need the services anymore? Is that enough reason? Like someone has asked on the chat group, is it enough reason to just say your services are no longer required, or I'm not even going to give a reason, just go, as long as I pay you your payment in lieu? That's the end of it. And then deprive someone of his livelihood. What do you think is progressive in this respect? Is it progress for the employer? Is it progress for the employee? Or progress for all sides and for the society? What's your view as a business person and as a lawyer?
So thanks, Jamil. And I will preface by saying two things. One, this is my personal opinion. So no one should quote me anywhere and say Coca-Cola said. No, this is my personal opinion for starters. And I'm just going to leave my video on. In the event that anyone can't hear me, please just say so I can turn it off because of the network. So on this particular case, and I've listened to what everyone has said, and even considering the things I have read leading up until now, I try first of all not to comment on what the rationale could have been by our counterparts in the corporate industry for the decision that they took. So I would rather just shy away from speaking to the rationale behind why EcoBank did what it did or did not do, or if it was right or if it was wrong. I just focus on the case. And on the case, when you think about it, I do understand and see the rationale behind why the courts would say, give a reason. And the truth of the matter is, if we want to be honest and fair, we do have a system which does require someone or somebody overlooking it with some rules to guide the relationship between employer and employee, really and truly, just because we're coming from a master-servant arrangement to achieving an employer-employee arrangement. So I can see the rationale, and I think it was in light of that the NIC's powers were expanded to cover the jurisdiction that it covers. Whether people agree or not, whether people align with that or not, the truth is the NIC can at least have regard to good or international best practice in reaching its decisions. And in doing so, it's really a question of fact. So what can you plead and prove? That's really what it's about. And so I see rationale. I see the reason behind the approach of the court saying that employers should give a reason. But my problem lies with the ability to define what is a good and reasonable reason. Because if I recall correctly, in the Pengerson case, I think it was in the Pengerson case that the court said, your services are no longer required is not a good reason. It's not a good enough reason. And you see, that's where my problem is. My problem is in the determination of what stands as a good reason. Because if I look outside even this case now and just look at circumstances and situations where employers and employees have to separate, right? It could be for whatever reason. As a company, I mean, look at let me not be so whatever, but look at marriages. The marriages that separate for well, I say reasons not too far from your services are no longer required. So in such a situation, what constitutes a good and valid enough reason? That is what I want clarity on. Because as far as I'm concerned, if an employee's services are no longer required, and in certain circumstances, the company can justly say so as a good enough reason, then what we should be discussing is the payments, additional separation payments, or whatever it is that the company should make in that circumstance to compensate the employee for the separation that has come up all of a sudden, because perhaps the employee thought that they still had a longer time with the employer. Can everyone still hear me? I'm sorry, when there's dead silence like this, I
Yes,
worry.
please. Very clear.
Okay. So in my view, that is what we should be talking about. What constitutes a good reason? We say, oh, it should be tied to, I think there's a case that says, or someone did mention, there's a case, yes, that says it should be tied to the employee's performance, etc., etc. The truth is, in business, the metrics as to why you want an employee today can definitely change tomorrow. So it can't always be tied to the employee's performance. Sometimes it's just a business decision. Sometimes it's much bigger than whether the employee performed well or not. Now, in this particular case, like I said, I cannot comment on the circumstances that led to EcoBank doing what it did because I was not there. I'm not part of the team that handled it. Yes, the court, they've gone to court, they've proved their matters. The court has taken its decision. But I'm saying that in the bigger picture, sometimes it is much more than the performance of the employee. It's strictly a business looking at its factors, or the factors that have changed over time, and determining, in the scheme of things, whether this employee is still, for example, someone who can take them to where they're going, or if these services are just no longer required. So that's where my concern is. How do you determine what is a good enough reason? And are we going to keep badgering on this particular line item as a professional body, or are we going to try to get an employee a good compensation if they invent that they have to be let go of in such a circumstance and the company just does not have policies in place to guide that? So that's what I would be concerned about in such a circumstance, putting that employee in a position where they can at least take care of themselves appropriately, until they do find something else that they can do in line with their professional abilities. So that's just my immediate thought on this line item. I think sorry, Jamil. Yes.
Yes, please complete your thoughts.
I was just saying, did I misread, or did the court actually order the reinstatement of the gentleman?
Yes, the court ordered the reinstatement.
I was hoping that I misread that, because I looked at it, that was another thing that concerned me, because I thought this is not a statutory relationship. You're an employer-employee, it's a private arrangement. You cannot force him on me as an employer, and you cannot force me as an employer on him. So why start what we can't finish? If it was a resignation and the employee was leaving, and employees resign for all sorts of reasons, but they don't tell you what those reasons are. They just tell you, I'm leaving, and they don't say why. So if we're balancing, and I'm sorry to shake.
Most will tell you, and this has been comical, most will tell you that they just want to go home and think about what next to do with their lives.
I'm telling you.
My Coca-Cola the next week.
I'm telling you. And then nobody comes to pull that employee and say your reason is not good enough. So if we're equating this contract and we're saying we're no longer master servant, we're equal partners, then if you're telling me I need to give a good reason as an employer, then you should tell my employee the same thing, and vice versa. And then let us determine what constitutes a good reason. And where that party or either party does not give a good enough reason, then what is adequate compensation in that circumstance? I think that's what is really, in my view, most important in this case. Thank you, Jamil.
Thank you very much, Ifedayo. Well spoken, like a true expert. And, I'll just latch on to a couple of things that you touched on in giving your speech. And you know, in preparing for this webinar, I had to, like I said earlier, I had to go read all the decisions. One thing that I would like to give as a gift to every practitioner on this call, maybe not for the business, the HR people, you know, they're not lawyers. Maybe they don't have all the time to do all the detailed reading that we do as lawyers. But one gift I will give to you is you should go back and read the ILO Convention on Termination of Employment, Convention 156. Read the recommendation that followed that convention in detail. What you find in many of the cases, EcoBank and all these cases, is Article 4, Article 4, Article 4. Article 4 is just one out of 11 articles or more of that convention. And if you read that convention from top to bottom, like I have, I do not think we should be crying over spilled milk. You know, just like Ifedayo has said, whether you like it or not, the position of the law today, as far as employment law is concerned, is you need to give that reason. So I'll be more concerned with the practitioner trying to find out, okay, so what is a valid reason? What is not a valid reason? Just like Ifedayo had asked brilliantly. And you'll find the answer in those in the convention and the recommendation, which has limited the reasons. I mean, what constitutes valid reason for termination to, number one, capacity. Number two, I mean, the capacity of the employee to do his work. Of course, if an employee had an accident, becomes incapacitated, I mean, you know, he can no longer perform. It could also be performance, low performance, which you need to show. Okay, when you came, you said you are the topmost expert in labor and employment law. Now you cannot even draft a termination letter. What kind of expert are you? You can't improve. So that is capacity. Conduct, it could be behavioral, it could be anything, it could be theft and all of that. Then number three, which I think is very germane to that EcoBank case, and actually came up in that case, is where the business reorganization of the employer requires it. And that last part is where I think EcoBank would have gotten a leeway in that case, because they actually said, oh, we were doing the right sizing. But the court said, this is an afterthought, because in your letter, you should have stated there that we are right sizing, we are doing redundancy, we are affected, you know, sorry, blah, blah, blah. And it would have been a perfect reason, and the court would have nothing to say about it. But they didn't say that. It was only in their court pleadings that they raised the issue. But if you now go through the convention, you see all the exceptions where the court said, yes, for these categories of workers, this convention does not even apply to them. People on probation, people on short-term contracts and all of that. I don't think practitioners are looking at that. Then the recommendation goes to say countries can make exceptions for this category of workers. Then this is what you should pay and all of that. So let's look at that and see how we can push the envelope in, you know, advancing this issue. So if the NIC wants to hold on to the convention, let you know, practitioners to then, okay, this is the convention. I want to come under this exception, and let's see what happens. And you know, that will move me to Solomon. You know, you are an international scholar. You are now in Washington, D.C., I guess, having tea. I don't know whether in the evening or having steak dinner and all of that while we're here in the tropical heat. But tell us, from an international law perspective, especially with regards to what is international best practice, I see that there's a lot of vagueness and ambiguity as to what constitutes international best practice. And I think most practitioners, or even the courts, as you know, giving Philip to that misconception that when you say international best practice, just ILO conventions, and I think not. I do not think that is the case. I've been in cases where Honorable Justin Kayep applied the opinion of an Indian text writer in a training bond case. So what is international best practice? What are the things businesses should be looking forward to that the court can have recourse to in giving decisions? So when we say international best practice, what is international best practice? And while you are at that, also address, please, this issue of whether the process for making those applicable in Nigeria. I've had pushback from someone who I can see is on this call on whether our constitution allows you to just, by general provision, import all the laws of England and Wales and all sorts of countries that are not even common law jurisdiction into Nigeria. Do you think relying on the ILO Convention, which for full disclosure has not even been ratified by Nigeria? It hasn't been ratified by Nigeria. It is even after ratification that you can be talking about domestication by law. But here, Nigerian is basically not in the picture when it comes to this convention. And here we have our courts applying this convention. Is Section 254 of the Constitution, Section 12 of the National Industrial Court Act, enough to give the courts that power, those powers? So, as the international lawyer amongst us, can you please, in 10, 15 minutes, guide us as to what we should be looking at in this regard? Thanks.
So, like, if Edaya had asked, what constitutes valid reason? What constitutes best practices? There's no universal answer to this question. And it has to depend on the facts and circumstances of each case. Of course, Article 4, like everyone has pointed out, sets out basically 3 grounds that has to do with conduct, the organization of the entity in question, or misconduct. Article 5 goes on to set out things that should not qualify. Should the definition of what is valid now include everything not set out in Article 5? It's still a debate among scholars, and there's no consensus on that. Practically, Article 5 says reasons such as membership of a union, being a representative, seeking to assert working rights, all sorts of things, they cannot be justifiable ground. The other argument is, should we not define what is international best practice to include every other thing that is not stated in that Article 5? And when it comes to what is internationally accepted, like I said, there's no consensus. It depends on the facts of each case, and it's still a debate in the public out there. So that's why I think that Bello and the likes shouldn't be a one-size-fits-all. I still think that instances and records should be given to each case, the peculiarities of each case, the facts of each case. And I also do not think that in adhering to international best practice, that the court should overthrow the concept of sanctity of contracts. For instance, if a contract expressly states that no reason should be given, the court should not go fishing for a reason. This is contract, and we should respect sanctity of contracts. And I think in as much as our courts are trying to be progressive, we should bear that in mind. Of course, we also pointed out, like in Bello, there was an antecedent of bias, witch hunts. Should it be sufficient when the court infers such things to apply international best practice? And who determines this? At what point is it determined? These are questions that are out there hanging out, and scholars are trying to opine on different aspects of it. Then I'll move quickly to the issue of domestication and the ratification. It's been a heated argument, and some people like
So, Solomon, your audio is quite bad. I'm not sure if it's just my connection.
No, it's across.
Okay. Now, there are arguments as to whether ratification is the same thing as domestication. Some people have argued that it's just a one step that takes care of the two. But then again, if you look at the term of Section 12, it's clear that for such an agreement to apply in Nigeria, it must be by an act of the National Assembly. And we find out in most cases when we say Nigeria ratified a convention, usually an executive act, usually taken by the Federal Executive Council, and the instrument of ratification is deposited sent to the entity that from where the agreement originated. So I believe strongly that ratification and domestication are two different things entirely. And we have some case laws that have actually decided on that. I have a slide that I would have projected, but for time constraint. Secondly, the issue of the ILO, International Labour Organization Convention in question. We should know that the International Labour Organization has about 190 conventions. And out of these conventions, Nigeria had only ratified 40, and some of them have even been denounced. The particular one in question, the Termination Convention, has not been ratified. But interestingly, in Bello and Ecobank, the NIC seems to somehow suggest that it has been ratified. Well, that is contrary to Aloysius versus Springbank, where the Aloysius versus Diamond Bank, where the NIC Port Harcourt division clearly held that although this convention is not ratified by Nigeria, it still went ahead to extract principles from it. Of course, it's debatable whether these decisions can be had on appeal. If you look closely at this decision, in the long run, at the tail end, the courts will usually rely on international best practices and not strictly by any specific provision of the ILO Convention on Termination. And I think since Section 254C empowers them to apply international standards, I think this decision should be able to stand. The fact that they mentioned or erroneously passed the picture that the convention had been ratified shouldn't actually impact on their decision, when in fact they didn't eventually rely on them as the basis for their decision. This also goes to another issue of, do we need to plead this convention before the courts can rely on it? What happens if I don't plead the convention, whether ratified or not? I think the answer is in the Evidence Act section 122 that says that that sets out matters and facts that Nigerian courts can take judicial notice of, and international agreements and conventions that are yet to be ratified or domesticated, depending on the school you belong to, are not one of such facts. So you need to plead them. Nigerian courts do not act on facts not pleaded. Again, another question will be, has Section 254C brought international conventions that are labor related within the purview of Section 122? That is, have they been made to form part of Nigerian law? Because that section says that NIC can apply conventions that have been ratified. So there are some of these conventions that have been ratified that have not been.
Hello?
You take it to mean when it comes to I see.
Hello, can anyone hear Solomon?
Yes.
Okay. So that must be me then.
Okay.
Please continue.
So I was saying about.
We have about 2 minutes left. Sorry.
Okay, I was talking about the issue of if I don't plead these conventions, will the court rely on it here? So I was trying to make a distinction that when it comes to labor-related treaties that have been ratified, I think they should be covered by Section 122. The Constitution's intention is that when it is related to labor, they are form part of Nigerian law, and by Section 122, the courts are to take judicial notice of such instruments. So, in the long run, I think to on the side of caution, employers and HR managers should be able to be attuned with these developments. Whether these decisions are right or wrong, they are extant, and the law is that a decision once given is binding. Until they are set aside, I think we should tread with caution and, as much as possible, try to comply with international best standards, whatever it might mean in your opinion. Thank you.
Yes. Thank you. Thank you very much, Solomon, for that brief but germane exposition of the process of ratification. Like you said rightly, there are different schools of thought about what ratification means and what domestication means. If I remember my constitutional law very well, that's when you get into the realm of the monist school and dualist school, whether the National Assembly should be part of the domestication at all. You know, all of that is there. But there's been the argument, I don't know what your view is on that. There's been some argument that the Third Alteration Act, by which the jurisdiction of the National Industrial Court was expanded, is in itself, of course, it's an act of the National Assembly, satisfies that requirement of an act of the National Assembly to import these laws into our jurisprudence. So the thinking is, if the argument of those against the importation of ILO conventions is that, oh, what Section 12 of the Constitution says is that you should bring a bill before the National Assembly, and then National Assembly has to pass a legislation domesticating Convention ABC and making it part of Nigerian law. When you look at it, there was a Third Alteration Act which says National Industrial Courts will give you the powers to adopt international best practices, and that is law. And that is what was copied and pasted into our Constitution as Section 254. Can anyone still argue that there has been no domestication? What's your view on that?
I think my view is clear and it's straightforward. It has to do with conventions and practices that are labor-related. Once it is labor-related, by its virtue of that section, which says that notwithstanding anything to the contrary in this Constitution, such conventions that are labor-related should not be brought within the agreements of dualism, monism. It should be taken that they are part of Nigerian law once Nigeria has ratified them.
Okay, that's quite clear. Thank you. I'm sure many people are getting ready their hammers to, hammer at you during Q&A. So, but let me ask Busayo, because you lost some minutes while you were giving your speech. The general mood across the table here seems to suggest that we're in a new era. Nobody should expect the common law era to come back anytime soon. Or maybe you wait until you can get to the Supreme Court, maybe. But in December 2020, there was a decision of the Court of Appeal in the case of Sahara Energy Resources. And what's the name of the employee? I can't remember. The Sahara Energy decision, where the Court of Appeal basically stamped the authority of the National Industrial Court. Okay, yeah, I remember. In the case of Sahara Energies and Oyebola Adewun, where the Court of Appeal basically said, as far as employment and labor law is concerned, the NIC has absolute powers to apply what it considers to be the best practice. The Court of Appeal would not overturn such decisions merely on the ground that you this instead of applying it. And don't forget that the Court of Appeal, as it stands today, is the Supreme Court in terms of employment and labor matters. The question to you is, with this kind of scenario, with this kind of setup, do you see any space from a practitioner for this to change in the immediate future? And if it were to change, or if an argument were to change for that change, what do you think are the reforms that should be made in that realm, especially on this issue of termination at will, which has now been to termination with cause?
Thank you, Jamil. My position on that is that as the Third Alteration and the Third Alteration Act and the Constitution rightly says, the National Industrial Courts has the power to apply international best practices in labor when deciding on issues bordering on labor and employment and industrial related cases generally. So it's my view is that clearly is the position of the draftsman of that law, that when this court sits to adjudicate on labor related matters, it should apply international best practices to such issues. And I think personally, I commend the Court of Appeal for taking the position of the constitutional amendment and shifting away from the old dispensation of common law. Because, and on the question of if there would be a change to the old dispensation, which is the position under the common law, well, I belong to the school of thought that the current dispensation as we have it has come to stay, and I'm not looking forward to the position changing anytime soon. And personally, I don't even expect it to change. That's my position on that.
Okay, I hope that's comforting enough for your clients. But I agree with you to a large extent, really. I mean, it's a new era. I think what businesses can do is to just adjust to the new reality and try to do things in the proper way according to the new era. And talking about the shift from the old to the new era, Motunrayo, I'm not sure if you've had cause to go through this research in the past, but one of the things that struck me when I was doing my own readings on this issue is that when you come to think of it, what we are arguing over or debating over now.
I've not read the case. I don't even know about it.
Okay, please can you mute everyone who is not speaking? So, Motrayo, like I was saying, I said when you come to look at it, there really is nothing novel in what the National Industrial Court is doing now, is there? Because when you look at it, even with the case, the state of our laws today, there is actually a dual system between the public employees, if I can put them that way, people who work with government, who we refer to their employment being regulated by statute, and private employee. And you find out that in the public sector, you cannot terminate an employee without reason. In fact, you cannot terminate them without going through what the civil service rules provide. And then, of course, in the public service, reinstatement is an appropriate remedy if the method of disengagement is found to be wrongful. And what is interesting to note, for those who do not know also, is that that has not always been the position. That position is actually a change from the common law position of the Crown's prerogative to dismiss its servants. And the Supreme Court at some point said in cases like Shita Bay and the Federal Public Service Commission and other cases dealing with Olaniyan and the University of Lagos, say, no, this cannot be right. You cannot just send someone out without, any reason and without following procedure. And if we find that is wrong, we'll reinstate. And I haven't heard any practitioner seriously argue against that, to say, why should this be the case? We all accept it as a truism, to say, oh, in the public service, yes, reinstatement is possible. Yes, you must give reasons and all of that. Why do you think there's so much resistance to that same measure being applied in private, for private sector employees in your view? And do you think the common law is so sacrosanct, is so beautiful that we must stick to the common law when the owners of the common law, so to speak, the English, the UK, have moved away from the common law to this new dispensation of unfair dismissal and all of that? What do you think about that?
Well, I would agree with you that there is really resistance from the private sector, because these things are actually not new. In employment with statutory flavor, you have to give reason, you have to follow the procedure for termination and all of that. But I think the reason why it is, and this is just my opinion, why it is resisted so much is because, you know, the private sector business owners are really just concerned about making money and profit. They don't want to be tied to, oh, I have to give a reason for this. I don't want you to work for me anymore, should be sufficient. And really, if the owners of the common law position are really moving away with this, then it's an evolvement, really, and it's admirable that the courts are trying to evolve with, you know, what is being considered to be accepted globally.
Okay, thank you very much for that, Motunrayo. So I think we should just move straight on into Q&A. Some questions already dropping in the, okay, so there's some questions. And please, as you're posting your questions, you could please direct it at any specific speaker or make it general. I have a question here from Nina Easy, who thanks the panelists for the arguments advanced and wants to know, wants us to share our thoughts on how the NIC should address matters that have express local legislation that contravene international best practice. I think I've written an article on this before. So the question is, if you have a local legislation, say your Labor Act, your Trade Unions Act, and you know, all of that, can the court or should the courts be permitted to leave that and then start shopping abroad for international best practice? In other words, is our international best practices now going to trump our own local legislation where there are similar provisions on the same issue? Ifedayo, your thoughts?
Jamil, knowing you is becoming dangerous on this panel. So, this is the way I see it. If we have local law, and the local law is specific, our constitution and the way our laws are drafted means that those local laws stand. The court cannot, how do I put this? The court can fish abroad if it doesn't have sufficient local legislation or local laws to promulgate on. So even with the provision in the NIC Act 716, it's the idea behind it is not to derogate from local legislation, it's to build on local legislation. So in other words, except there's somewhere in black and white in the Labor Act, for example, that says you can, what's it called, hire and fire at will, then it hasn't derogated from the act. It has built on what is provided in local legislation. So that is the way I see it. Once there are provisions in local legislation, those are the foundational starting points. So that's where the court starts from. It starts from what does local law provide and what does local law have. Then where there are gaps in that local law, or where it stops somewhere but the court needs more, or there's a need for growth from where the local law has set the foundation, then it can now look outside to say, okay, this is what local law says, but to take it from here to the next level, or to introduce growth, or to be able to answer this question, because there's a gap in local law here, or the local law has provided this, but I need to build on that to be able to give more. It's like the relationship between the CAMA and the company's regulations, even though right now there's an argument on that one, which hopefully we shall deal with very soon. But that is like the same thing, the relationship between the CAMA and the company's regulation. So there's local law, this is what it says, it stands. Everything else should be a build up on that. And that is where international law comes in. I hope you understand where I'm coming from. Jamil,
Perfectly. Okay. I understand that perfectly. And I actually agree with you that's always been my position too. I wrote an article in 2013 regarding the case of Ejike Maduka and Microsoft, where that's the first case on sexual harassment by the NIC. And the NIC relied on CEDAW, Convention on Elimination of Discrimination Against Women, to make far-reaching. That was a case that the manager touched an employee's waist and ended up paying 36 million naira in damages, you know? So, and I think that's the way it should be. Otherwise, we'll see an abandonment of our local laws, which, yes, the laws are archaic in a sense. And so I see that the judges have found a shortcut in this new amendment to the Constitution, as opposed to a proper amendment by the National Assembly. So if the National Assembly is not doing its work in promulgating progressive labor laws, our Labor Act is 1945, if I'm not mistaken, or 1970s. And the most recent labor-related law we should have would probably be the same-sex marriage law, or maybe the Employee Compensation Act of 2010. And this is a field that develops, you know, at the speed of light. So this is a shortcut for them to go and import what is current as opposed to local. And of course, before you know it, nobody's referring to the Labor Act. I don't think that's the intention, and that should be the case. So I agree with you totally. There's another question here, not addressed to any particular person, and it's from Adiola Agumbi Adeyemi. And she's asking what the panelists think about the seeming conflict between Section 254C H of the Third Arbitration Act, which touches on application and interpretation of international labor standards, and Section 254C sub 2, which suggests that as far as conventions are concerned, they must be ratified first before they are applied. I think that question has been answered in the course of our conversation, except anyone else wants to briefly recap or elaborate. Solomon, do you want to do that?
I think, like you said, can you hear me?
Yes, please.
Yeah, it's been answered already, but I wanted to touch on the earlier question. I'm not sure I got the question correctly, but I think I followed from your response and the Fedayos response, which are apt to the on what you said. But again, we'll also look at it from international law perspective. We know that treaties that have been ratified, accepted, and domesticated rank higher above national laws, as it is a well-established principle of international law that a country cannot evade obligations under international treaty by its national law. So we also have to look at the kind of obligation in these labor law issues. Who are the parties to it? Are there some foreign obligation to them? There are, and there are international treaties that Nigeria has signed up to and have been ratified or domesticated, depending on what we take it to mean. Then I think they should come higher than national laws. It's a long discourse. Second, this particular question here, I think the question is confusing what he said in the earlier sections, earlier subsection to the one that talks of ratification. The first one talks about applying international standards. The other one talks about conventions. There are two different things. Conventions are kind of treaties that a country signs up to, and if it wants it to continue to bind its citizens, it takes it home. And again, the debate on ratification comes up. But by provision of that Section 254 C2 that says that when it comes to international labor conventions, ratification is sufficient. I think that answers it. Hello?
Yes, thank you, Solomon. That's quite clear, and I hope you've been able to satisfy the person who asked the question. There's another question here which is addressed directly to me from Mr. Nonso Azi. And the question is, what do I think would be the approach of the court where an employee was laid off on a supposed redundancy, which turned out to be false. There is evidence the company is financially very buoyant and doesn't have surplus manpower. What if the employee had been paid off upon disengagement? Can such employee claim for the income she would have earned had she not been disengaged on the strength of the fictitious redundancy? Okay, so my views, this is an interesting question. And I think in some way, very relevant to what we are discussing. You remember that when there was a point in the discussion when I spoke about the fact that one of the permissible reasons that the ILO conventions, not even Nigerian law now, the ILO convention itself says, yes, you can lay off an employee is on the ground of business reorganization. And of course, redundancy would fall under this category. What that means is that, yes, the employer can disengage this employee based on redundancy. So if it then turns out that the redundancy was fictitious, which means there was actually no circumstance leading to redundancy, then it would mean that the reason given was false. And I think for me, the simple implication of that is the employer would not be able to justify that reason if the employer was taken to task on that by the employee. So an employee, a disengaged employee, goes to court and makes a claim to say it was let off on a redundancy and that the redundancy was fake, let's put it that way, because the company is doing well, they don't have surplus manpower, so where's the redundancy? If he can prove all of that, it means he will be able to succeed in that claim. One other thing that I should also point out, and it's good this question is bringing that to the fore, is that when you go to check the ILO Convention on Termination of Employment, since that's what is like the guiding whatever of our courts now, you will see that it actually shifts the burden of proof or fixes the burden of proof on the employer to give valid reason or to justify the reason why the employer was let go. So in this case, it will be the employer coming to court to justify the fact that there were circumstances giving rise to a redundancy, and that's why this employee had to be let go. Of course, Section 21 of our Labor Act tells you what a redundancy is. The second part of the question, so what happens if the employee had already collected money and gone? What then happens? Neither here nor there, depends on the attitude of the particular judge, but based on what we've seen so far in the case law, the employee can actually make a claim to recover damages for loss of employment. That is my view. How much and how long that would be is not yet certain with the different decisions we are having. But in the Sahara case that was delivered in December, it was a case that actually dealt with issue of quantum of damages to be paid to an employee who was found to have been wrongfully terminated. And I think the court awarded about 2 years salary or so. I may be wrong in that case. The interesting thing is that this measure of damages, when you look at it, is also contained in the ILO Convention, which is why I'm advising everyone to go and read that convention from beginning to end, because you see that most of what is there is already what our courts have been practicing in some form or the other. So that convention says that when someone is found to have been wrongfully terminated, the damages should not be just 1 month's notice. There should be a severance package. There should be benefits calculated based on length of service and whatever other percentages. So that's my answer. I think the employee will be able to, get additional damages in addition to what he has been paid before. I hope I have been able to answer that. We'll stop by 12:45 because I think our time was meant to be 12:30. So maybe we'll take 1 or 2 questions more and we leave. I'm just trying to access the questions. Okay, I've seen it. So this is from Chinedu Nwobodo. Okay, well, but this is a comment actually. It says that I am bothered that the National Industrial Court, in applying the progressive approach, loses sight of Article 10 of the same convention, which contemplates that national courts should not order reinstatement where it is not practicable, notwithstanding the fact that the termination is wrong, but should rather award adequate compensation to assuage the injured employee. Chinedu thinks that the draftsmen had contemplated where the employee will not have a conducive work environment if reinstatement is ordered. This is a brilliant comment, and I'm going to throw it open to the panelists to answer this question. I think it's something I'd also raised earlier in the discussion as to in what circumstances is reinstatement appropriate. In EcoBank, in the EcoBank case, the court tried to answer that question, but it didn't really get into detail. So anyone from the panelists, or do I pick and choose? Muturayo,
Okay.
what do you think? Oh, someone was about to speak.
Yeah, sorry, I was just going to say that Chinedu's point is valid because that's literally where it was
This is
coming from
better,
earlier
yes.
as well. Yes, so I completely agree with Chinedu. I completely agree with him. And the truth of the matter is, if in the EcoBank case, you could already see that there was the problem in that environment, be it from the employer and the employee or whichever way. It was obvious that they could no longer work together. And then in that circumstance, to order a reinstatement threw me completely, like I said at the beginning. I couldn't understand, first of all, the rationale behind ordering a reinstatement in a private arrangement, but even more in a circumstance like that. So I would say that our statutory employment is clear. Where the employment is of statutory flavor, it's clear that in those cases, because it's statutory, and the rationale is simple, because in statutory employment, people move around, it's government-based, it's based on statute, the appointments happen. So even if the environment may not be 100% today, the likelihood is that there's going to be a movement very soon. And people, I call them civil servants, even though I'm not a fan of the word, but the civil servants also enjoy a lot of amenities and the likes that they lose if they lose their position. So that reinstatement becomes like really critical for them. In the private sector, it's not exactly the same. And I think that when it even comes to a case of reinstatement, maybe the court can consider throwing out that question, or you put it in a mediation session. Let the parties align on that and say, do we really still want to work together? Even if you say, okay, have a session outside of this court's hearing, and then come back to me and say whether you want to work together. If you don't want to work together anymore, then we can now look at increasing the compensation that the court has already given, perhaps, just to help that, or to basically sort it out from a compensatory perspective. But to force, I don't think there's no wisdom, because even if he goes back, there is all that they've done is giving the company a lessons learned platform to build on. And there's no guarantee that he will not be frustrated in the system. I'm not saying that that's how the EcoBank system works. I'm just saying that generally from a human being perspective, one human being to another, that could happen. Thanks, Jamil. Sorry to have jumped in.
No, not a problem. I was actually glad that you jumped in. Moturayo, what do you think? Do you have a contrary opinion?
Well, I think I would agree with Ifedayo on this. The environment may be very hostile, and if compensation would be sufficient. For example, in the case of Afolayan and Skybank, this person had been suspended for about 3 years, and that was when the termination came through. I would assume that she wouldn't have remained unemployed for 3 years, for example, and then it was after then that the court, ordered reinstatement. If it may actually be easier, like she said, in the public sector, where this issue would be, very important that the person is reinstated to get all of his or her benefits. But in the private sector, the issue of compensation may be sufficient in the circumstance. If the employee goes back and is being frustrated, then that could now lead to a case of constructive dismissal, and it just goes on and on. So
yeah, that's quite right. The only thing I have left to add on that point is when, like I said, when you read that EcoBank case, the courts broached very lightly on the reason why it was ordering reinstatement, but didn't really dwell on the legal reasoning behind the issue of reinstatement. But if you can borrow a leaf from the jurisprudence, surrounding reinstatement, and especially the way it is applied in other countries. In the US, for instance, a claim for reinstatement is always usually made for undertakings or establishments that are very large. So the thinking is, if you have a 5-man company or firm, Jamiu, Nonsoazi, Fedayo, Motunrayo, Solomon, and Busayo, and co. It's just 5 of us. We're in the same one room, 2-bedroom flat, practicing law. If one of us doesn't like the other, we can't miss one another every day. We see each other every day. We work in close proximity. So if there's bad blood, there's bad blood, and it would affect the work. But imagine working in a bank like EcoBank, which was what the court was looking at. Hundreds of branches, thousands of staff. In the case of Mr. Bello, the court actually noted that, this is a manager who is actually supervising many hundreds of employees. So the people who are after him, he doesn't even need to see them. You can post him to Kano, post him. The court didn't say that, but that's paraphrasing the thinking behind the court's reasoning, which is in tandem with what you have in the US, for instance. So in large undertakings where there's not likely to be close contact between feuding employees, reinstatement can be ordered. So if you had an issue with your manager in the Lagos office, yes, you could be reinstated and you're transferred to Sokoto or Borno, to continue the work there. So I think that's the reason. But I think the point is taken that, look, maybe it's best even for the employee to just get paid damages and move on. But let the damages be something substantial for the employee to get pieces of his life back together. And that's what the ILO Convention and even case law have given for the reasons behind extending the measure of damages to our usual 1 month's notice. And with that, I'd like to close, end on this note. Thanks all our panelists for spending their lunch hour with us on this lunch webinar without lunch. I hope you find time to get a good lunch after this presentation, and I'm sure Esquire will foot the bills. I'll hand over to Chidinma of Esquire Magazine to now give us the closing remarks, and then we'll call it a day. Chidinma.
Thank you, Mr. Jamil. I must say this has been a really robust and insightful session today. The topic has, it's fully packed. Thank you to our speakers, our chair and moderator, Mr. Jamil Akolede, Mrs. Ifedayo Iroche, Mr. Busaya Dedeji, Mr. Solomon Ezike, Mrs. Motunrayo Olale. Thank you for the very rich and well-researched content that you have shared today. We appreciate that it takes time to prepare for events like this, and we appreciate you're taking out the time from your busy schedules to do this. Especially, we thank Mr. Jamil Akolede once again for making this insightful book of employment law handbook available, and the video we are going to play it shortly. It's going to come on now, so you have a look and see where you get it. A very big thank you to our sponsors, GLIS and Co. and Advocate Law Practice for making this webinar possible today. Thank you also to all the attendees participating in this webinar, all the questions. Thank you, they're really insightful. Please note that our next webinar series titled Cryptocurrency and Other Virtual Assets Regulation in Nigeria, Legal and Economic Constitution, very hot topic, you don't want to miss it. To be coming up on Monday, 15th of February 2021 by 1 p.m. on Monday. It promises to be very informative. We look forward to engaging you all. As I mentioned earlier, registration is ongoing for a 12-week virtual distance learning course on power titled The Dynamics of Power Contracts, Regulation, Contracts, Negotiation, Documentation, and Project Financing, which commences on the 16th of February 2021, and you cannot afford to miss it. And to get more information about all this, please send a link to Sholanke and Co. To get more information about the book, please contact o.sholanke@esquire-law.com. Thank you so much for attending the webinar today. Thank you to the speakers. Thank you to all the participants. And God bless you.